I'll go ahead and kick things off. And for those of you, let me reshare my screen here. I think it's not sharing. There we go. For those of you who are not overly familiar with Domain Money yet, I'm Adriana. I'm the head of financial planning here at Domain. And Domain is a modern financial planning firm where we focus on where you're at today and what you're trying to achieve and how we can help you get there. So flat fee financial planning, we don't do AUM or assets under management or anything like that. Just really straightforward, actionable plans to make sure that you can achieve all of your goals. Another thing I'll note is that all of our financial planners at Domain are certified financial planners, which is the gold standard in the industry. So we will always have your best interest at heart in the plan, and we are a fiduciary. So we are obligated to act in your best interest in anything and everything that we recommend for you. Today, we are joined with our friends over at Steward. I'm really excited to introduce them in just a moment, but I will also note that we're going to do a Q&A at the end. You're welcome to send questions in along the way as they're top of mind. And if anything is super relevant, I'll make sure to include it in the presentation, but we will also tackle all Q&A at the end. Any questions on domain money, on estate planning, on Steward, send them all my way, and I'll make sure that we cover it all. So I am really excited to introduce our team at Steward. And at Domain, we have a couple different tiers of financial planning. We have our essential membership, our strategic membership, and our comprehensive membership. Our comprehensive membership is what includes the comprehensive estate planning with Steward as well. So that is how you would get access to cover everything that we're going to talk to today, if this is relevant to your situation, or if we're just kind of figuring out where you're at and what you need to get started on and what you should be thinking about. And one of the core values at Domain is keeping more money in your pocket and helping you achieve your goals, as I mentioned earlier. And estate planning is a really great way to accomplish that in a couple of different ways, which I'll let Meg and Samantha get into. But to introduce Steward as a company, they are a modern estate planning firm that really combines a human-centric approach to estate planning with technology to make for a really awesome client experience that's much more technology advanced than the traditional options that you might have with working with a local estate planning attorney at the office downtown, for example. So I will turn it over and let Meg and Samantha introduce themselves. Meg is head of client success at Steward, and Samantha is head of legal. So I'll let you guys go ahead.
I guess I'll go first. Hi, my name is Meg. As Adriana mentioned, really happy to be here with everyone and talk more about estate plan and how we can help out and just educate each of you. But I am head of client success here at Steward, as Adriana mentioned, and I am just outside of the Boston area. I've been in the estate planning world for the past 6 years. So while I am not an attorney and won't be able to provide anyone legal advice, I do have a lot of knowledge and can help clients just learn more about estate planning as they're going through this process, many folks for the first time. And on a personal note, I have a 2-year-old son, and he is the light of my life. Samantha?
Samantha, can everybody hear me okay? Just want to make sure. Okay, great. I am head of legal or legal advisor, as Adriana mentioned. I started my career about 10 years ago, straight out of law school in the trust and estates world. So I've been doing this for what feels like a very long time. I've concentrated heavily on ultra high net worth individuals, and then I recently transition into helping stewards sort of make this a more accessible sort of service that I think everybody really needs. So that's it.
Awesome. Well, thanks. We're so excited to have both of you. And before I formally kick things off, I should also say that this webinar is for educational purposes only. And if you want personalized advice, to book a free strategy session with myself or someone at Domain Money, and we will help figure out what the best course of action is for you and make sure that you get connected with Steward via your financial plan with us as well, if that is the best solution for you. So I will go ahead then and kick things off. We're going to do just more of like a fireside chat here. So I've got several questions for you, Megan, Samantha, that we'll run you through. And would just love to hear your insight and everything on all the questions we've got in the queue that I think will be super relevant to everybody. So Meg, I'm going to start with you. So at Domain, our mission, as I mentioned earlier, is to empower clients to live their best life today while also ensure that they're planning for a very bright future. And I mentioned that estate planning is one of the best ways that you can ensure that you can accomplish this. Can you start with an overview of what estate planning really is?
Yeah, great question. Sam might have to back me up here a little bit, but everyone has an estate no matter what your net worth is. I think there's a large misconception around like estate sounds like it's for the ultra wealthy, and it's not, right? So an estate plan is a series of documents that plan for what happens to you after you pass away or in the event of incapacity. There's many different types of estate planning documents, but the core types of documents that most people are familiar with or will have for the very first time is either a last will and testament, a revocable trust, and pour over will. Those two documents go hand in hand. A durable power of attorney, which is financial decisions in the event of incapacity, and an advanced healthcare directive, which is also known as a living will. Those are the four core documents for the trust, and then the two incapacity documents, power of attorney and healthcare directive, can also be used alongside a last will as well. Again, there's many different types of other estate planning documents. Like people have, there's like an irrevocable trust. There's, Sam, what else am I missing here? There's
You're
many
doing
types
a great job.
of
Yes.
But yeah, I would say those are the main two that people often hear is like the last will or the revocable trust, and you kind of choose between one or the other, or most people will like start off with a will and then choose a trust later down the road, or vice versa. So yeah.
That actually brings up another question I had for you, either Meg or Samantha. But why is it important to have a trust alongside a will? Or like what would be a situation where it makes sense to have a trust on top of a will? Or if you could share like some examples and delineate who needs which one, or just some common scenarios that people might find themselves in so that they can relate to which ones might make the most sense for them.
Yeah, of course. So I'll start with just a general overview of what a will is. And this is the typical document that people think of when they think of estate planning and dying and how their stuff goes. So this is also a very important document for those of us with children. This names who your guardian is. So that's always one of like the reasons why people start getting interested in estate planning and doing their wills. Um, One thing about a will is that it goes through a process called probate. This is in every state, no matter what, it has to go through probate unless you have qualified for certain exemptions. And probate is a court supervised proceeding where the court sort of just makes sure that everything is being done correctly. It can be very time consuming and very costly. Another thing is that it is public. So if people were nosy, they could very easily just look up what was going on after you passed away and where your money was going and those sorts of things. There's something called a revocable trust that is a very common thing that goes alongside a will now. And together, the will and the revocable trust in sort of this modern day estate planning will together form your estate plan and act as what people would typically think of as the will. The revocable trust is something that is controlled by you during your lifetime. So it sort of just acts as your alter ego. So if you want to fund it, you can still take the money out. There's no sort of um, restrictions on how it can be used. And the biggest benefit for having a trust is that when you pass away, your all of the assets that flow through the trust, they avoid this probate process. So they don't have to go through this court proceeding. That's probably the biggest benefit. And alongside that comes privacy. And it helps just maintain continuity. So if you were to become incapacitated, then any assets in there could still be used for your benefit without the need for a guardianship proceeding. It simplifies the administration of your estate after you pass away. There's just a lot of really good benefits. It's easier to change, it's easier to make adjustments, it's easier for your kids to change down the line. So there's really I don't I'm not really aware of any situation where I think people would have only a will. It would be both. Um, yeah, so that's it.
That's super
Did you have
helpful.
anything? Okay, go.
Well, I have a follow-up question, of course. I feel like a lot of people, and I see this when I'm working on financial plans with clients, is that they think estate planning is only important if their estate is complicated or they have a lot of assets. You touched on like how children can affect this, but could you touch a little bit more on why it doesn't only apply to those with a high net worth, and maybe some instances of where it might really have proven valuable for somebody who has maybe doesn't have as high of a net worth just yet, but is building their family?
Yeah, definitely. So, as Samantha was mentioning, every state has a different probate process, and every state has also a different probate fee, or not fee, different amount or threshold that would require probate. So, like California, for example, I want to say it's like over, if you have a net worth of over 140,000, don't quote me on that. Um, then your assets would be subject to probate. So in other states, that is a lot lower. Like, say it's like $20,000 in Ohio. That is not correct, but say it's a lower amount. So if you have over $20,000 in Ohio, then your assets are going to pass through a probate process after you pass away, whether you don't have an estate plan or whether you have a will. An estate plan also allows you to do other important things. Like if you have minor children, it allows you to say who is going to be the legal guardian of your child in the event that you are no longer there. It also allows you to say, like, where you want your assets to go after you pass away. Maybe there's specific people in your life that you do not want your assets to go to, or maybe there's specific people in your life that you really do want your assets to go to. Same thing with like charities, or maybe the college that you went to, you want to donate a portion of your assets over there. An estate plan is really great for blended families. Again, planning for incapacity, avoiding that probate process altogether with a trust, and even protecting against creditors as well. You can, with a trust, there's different ways and strategies that you can protect your assets from ever going through creditor after you pass away, or preventing creditors from going after your assets that are designated to your beneficiaries.
Yeah, I feel like a lot of times too, I like to use the line with clients that everyone has an estate plan. It's just a matter of whether it's the one that the state you live in drafted and is going to impose on you, or it's one that you created yourself, right? And
Exactly.
most often we don't want the default of whatever the state we live in put together for us because our situation is much more different. So I think that ties in really well to what you were explaining about how it just every situation is different and it's not a matter of not having one. You might just have a template boilerplate one that someone else has put together for you if you don't create your own. And actually, that leads into another question I had of why is it important to take action now, even if your situation feels messy or unfinished? And like, if you know things are going to change in the coming years, can you update it? Like, what does the process look like if you have one in place that doesn't make sense anymore? Kind of throwing a lot of questions at you guys. So if you want to take it in steps, but really, like, why is now the right time to get started if you don't have one?
Well, I can start this one off, Meg, and then if you have anything to add. So I I know we've said this so many times, but it's never everyone should have estate planning documents in place, especially if you are married and have children, or if you have any assets that you think anybody might want at the time of your death. Um, so it's never too early to start thinking about this stuff. I know there are life events that come up that make people definitely more often than not start thinking about these things. So never too early. That being said, when they are put in place, so for example, I don't have children right now, and if I my estate planning documents will need to be updated if and when I do have kids, right? To sort of reflect a different plan to accommodate those children, to appoint guardians, to do all of those things like that I am not aren't necessary for me right now. That's one thing the revocable trust is good at is it's very easy to update, quick to amend. It's not a whole hoopla. Signing wills is like still very archaic. So it's like a very big ceremony a little bit. And updating a revocable trust is not like that. So those are times just like at different stages and different life events is when it would need to be updated. But it's sort of like you'll know it when you see it kind of in your life, you'll think to yourself like, oh, should I be changing this? Luckily, a lot of the documents definitely drafted at Steward and at other places, if done properly, it is doesn't need to be updated to reflect like a change in your net worth or asset circumstances unless there's something very specific that you want to handle. So they're flexible and can change with your net worth, with sort of the law changes that may come up, which seem to be happening very frequently now. So luckily, there's no changes that need to be done to reflect those. I don't know if I hit all the points. Meg, did you have anything to add?
No, I was just gonna say, like, yeah, the life events is usually a big one, like having a kid, getting married or divorced, buying a house, I feel like is a big one, or like coming across more assets or like naming specific gifts. I feel like that's not as common, but sometimes people are like, oh, I want to leave, I don't know, $50,000 to so and so now. I don't know. So, life events.
Yes, absolutely. And so, can you talk a little bit more about the process of what happens if you already have those documents in place? Because I think some of our attendees today, and certainly several of my clients, maybe did draft something years ago. And how do they go about amending them, or what does that process look like? And obviously, it can be different in other places. So maybe you could speak to how you guys handle it at Steward a little bit.
Yeah, absolutely. If you do have an existing estate plan and want to update that estate plan, and say it's been like 15 years or something, then you can with Steward, you can come to us and just let us know ahead of time in the consultation or during the onboarding, like, hey, I'm gonna update an existing estate plan, and um whether it is you had a will and now you're creating a trust, or you had a trust and you want to update that trust, we'll just add in specific language. It's called an amendment or a restatement in there. So it still reflects the same name of the trust that you had before. You're just changing the wording and specific wishes that you wanted to include there. So it's relatively easy, to say the least.
Okay, awesome. And you mentioned like amending a trust, but what if, correct me if I'm wrong, but in the will is where you would state your guardians for your kids. What if your sister and brother-in-law decide that they're moving to Bali and they're no longer in the US and they were who you had named? How easy is it to update the guardianship or something that maybe isn't in the trust?
So that's definitely a little bit more involved, I would say, meaning that you have to have two witnesses and a notary. That's like really the whole level of
Okay.
involvement. Um, with most trusts, all you will need, with the exception of certain states like Florida, for example, but all you would need is just for a document to be notarized to have a trust be like executed in accordance with law. For a will, it's you need two witnesses and a notary. Luckily, Steward handles all that if they're doing if you do it through them. But to answer your question specifically, when you want to update your guardianship and like, or let's say you move to a different state, although not required, it's probably a good idea to just like update your will, right, to reflect where your new domicile is. You would just execute a new will. You can execute something called a codicil, which would just like make the small change, but that's less it's the same like sort of steps to sign. So typically people will just execute a whole new will that reflects all their wishes. Um, so yeah, that one's a little more involved, but it's not, terrible. It's better if you don't have to go into a law firm to sign it and do all
Yeah.
of that stuff. But
And what about, is it just like the new date that overrides it? Or could you share a little bit more about making sure that the right will is passed on to whoever is going to be executing the estate, or how that works? Or like what would be the key that they need to make sure for maybe someone who is doing this right now with their family or something like that? Like, how do they know that they have the most up-to-date will?
that's a great question. So the rule of thumb is like the most recent document will always govern. But let's say, for example, I signed my will, in 2021, and then I signed another one in 2023, and then I died and somebody couldn't find the 2023 will. That's a problem, right? So I think to circumvent those sorts of problems, we would always recommend either just totally destroying the 2021 will, right? But then now you're saying, well, now I just don't have a will. Always keep electronic copies of everything. Keep all your documents in a safe place. If you've done it through a law firm, odds are the law firm has the original. If you do it through some place like Steward, you would keep the original and just have it and keep it in a safe spot. People use like those fireproof boxes, those sorts of things. So I guess the answer to your question is you just want to make sure that whoever you name as executor or your spouse or somebody that you trust knows where to look for important documents in your life, whether that be, birth certificates, the will, anything, like keep all those things together so somebody can easily access them if you are not around.
Perfect. I don't know if we have any crime junkie fans here, but they always talk about their if I go missing folder, which is very similar. It's that list of like where everything is, or like passwords to accounts if you need to track down like credit card transactions to see maybe if you really are out there somewhere. And so I feel like it's a similar concept. You should really have somebody that you trust to make sure that they know where things are in the event that it needs to be accessed. Um,
Yeah, to that point, one thing that should never be recommended is putting it in like a safety deposit box, because we've had in the past, there are like cases on this where people, in order to get into the safety deposit box, you have to prove that you're the representative, but like it's in the will, so you can't really, it's sort of a catch 22. So that's one thing that we would say, don't do that.
That's good to know. That's really good to know.
Or like in their safe, it's like, well, how do you access the safe if you don't have the code?
Yes, you need the whole trail of breadcrumbs
Yeah.
to to get in. Perfect. And you touched on something, Samantha, about every state is different, and Meg, actually, you hinted at this a little bit earlier too. So whoever wants to take this one, but I'll start with you, Samantha. We do have guests joining from all over the country and in different states. So how does it vary from state to state, aside from just the fact that probate might be different? Is there anything else that comes to top of mind?
Yeah, so I would say like the starkest difference and most prominent like buckets of differences is that we have some community property states and some separate property states.
Mm.
Community property, that's a state like California where all assets acquired during the marriage are both spouses' assets, half and half. And so when you die, you can get rid of only one half of that property. The rest stays with the surviving spouse. So that's handled very differently. Whereas in a place like New York, you don't have a community property state. And so everybody can dispose of their own assets however they want to. And these are just handled very differently. The way the documents look is different, and what you can dispose of when you pass away is different. Sort of piggybacking on that, some states, like New York, have a separate state estate tax that they impose when you pass away. Whereas places like California, Florida is I'm sure everybody knows Florida doesn't have an estate tax. So that's also handled differently, right? Like you don't have to worry about these tax concerns when you're passing away, because most people's secondary goal, I would say primary, is to just take care of their family, but like up there with that is they don't want to pay taxes, which is great and fine and can be done, but you have to know the rules. And so I think those are probably the two biggest and most important aspects of the different state laws. Did you have anything to add, Meg? I'm sure I missed a million other things.
I would say like, I mean, obviously like there's different statutes and everything. Like I'm just thinking about all the documents and like sifting through them in my mind. Oh, I think one thing that's kind of funny, this doesn't really apply to people, but like in Massachusetts, it says like Commonwealth of Massachusetts, whereas in other states it says like state of Florida, which is just like there's like funny little differences. But one more thing is that like I lived in California my entire life and just moved over to Massachusetts. Our estate plan still reflects California, like it still says California. It would be a good idea for me to update my documents to reflect Massachusetts, since that's where probate will be if I pass away. But it's the California documents are still legally binding.
That's a good call out. And that actually brought up another question I had about like the different states. Um, what if you split time between states? How do you determine, or is there rules on like which one would be your domicile, or do you have any advice for somebody aside from actually speaking? I know, back to the, this isn't advice kind of a situation. Like we would always recommend that you actually talk to a lawyer and make sure that you understand this. But is that a common thing, and how do you guys approach that?
Wherever your domicile, which is like 6 months and 1 day, correct?
It's interesting because, right, so you have that's the rule to not have to pay income taxes somewhere. So,
Yep.
a lot of people try to stay out of New York for that one extra day so they don't have to pay New York state tax, income tax. Domicile is a little more fluid when it comes to estate tax. And I actually had been working on sort of a probate where somebody had moved. It was an older couple. They had moved to Florida. They had been living in Florida for like 20 years, let's say, and they had like 2 years ago moved to back to New York where they had originally come from because their kids lived here, but they had moved for like medical reasons. And so when they passed away, what we were trying to sort of say is like, well, this doesn't count. They didn't change their domicile, their home from Florida to New York because they had moved for these like medical reasons. They really didn't have a choice. So it definitely is more sort of like a vibe thing, which is like obviously not a legal term, but it isn't as there's not a day accounting sort of mechanism. There's like case law and intent is like a very big deal. So I would say for those people who float between states regularly and they're not like planning to die now, I would say probably the safest bet is to do wherever you're an income tax resident, where you file your state income tax returns. Um, but hopefully by the time that it becomes relevant to determine for estate tax purposes or where probate should happen, like hopefully, you know, circumstances are different and you've sort of figured out how that will work.
I have one more piggyback question from the state perspective on that. How important is it that the attorney that is helping with the estate plan is in your state, or can they be in a different state and licensed in your state? Or if you could just touch a little bit on that, that'd be super helpful.
That's a good question. I think that, right, like the best course of action would to be have somebody helping you with your documents who is familiar and knows the rules and laws of the state that you are domiciled in. Um, Many people can be barred across different states, so I think that's sort of the advice is do that. Luckily, places like Steward and Meg can speak on this more. Like, there's a variety of lawyers with a variety of different expertise, and so they're able to like help across different states. I didn't want to say like state lines. It's not like a crime, but Meg, I don't know if you have more to say on that.
Yeah, no, exactly. Like we definitely have attorneys who are working in other states, and then they can support clients across the board and still give them legal advice. But if there is specific, like state specific legal advice, then we'll just make sure that that client works with a local attorney.
Okay, awesome. Shifting gears a little bit back to, taking the plunge and actually getting started with an estate plan. What are some of the things that people should think about before they actually sit down to maybe put some of these documents together? Like the first thing that comes to mind is like having a conversation with your partner or your spouse about who would be who would be the guardian of your children. So can you touch on maybe some things to like start the conversation as you start to think about this and get ready to begin drafting documents?
Yes, I would say the roles of the trust. So, who's going to be the guardians of minor children? Who's going to be backup guardians? Who's going to be the successor trustee in the event that you guys are no longer around? Who's going to be the beneficiaries and the backup beneficiaries? I've seen a lot of not conflict, but just like contention between couples of like, no, I don't want my family or I don't want your family to get any of our assets if we all passed away type of thing. So it's like it is interesting to see these conversations firsthand and like how people are thinking and the conversations that are coming up that they may have not discussed already. So where's your money going if all of you are gone? Who's going to be guardians of your children and the backups in the event that the primary aren't able to be the guardians? And who's going to be managing your assets after you guys are no longer around? And who's good with finances to manage those assets? I would say those are the core big rocks to think through for couples for sure. And then also like in the incapacity documents, the power of attorney and healthcare directive, it's like who's going to be making medical decisions if your spouse isn't there either, which is a big one. You definitely want to think about like people who live closer by. Maybe somebody in another country might not be the best option because they would have to make these decisions relatively quickly. Same thing with guardians. It's like, do you want your family living in another country to be the guardians of your children, thinking that your children are going to have to uproot the life that they are so used to and live in a different culture and get used to that country, perhaps, which might be a little difficult for them. So definitely thinking through all the hypotheticals and scenarios is key.
Definitely. And then along those lines too, maybe this one's for you, Samantha. What are some of the questions that you see families asking their attorney as they go through this process? So, like Mike, I think you touched on a couple of good ones, like where does that person live and like those types of things. But are there other questions that you commonly get or that attorneys commonly get during this process?
Yeah, I'll start with like a common guardian one since we sort of just were touching on that, which is, a lot of people want to be able to sort of like have a heavy hand in customizing how the guardianship works, which you can't do when you're gone. So it takes sort of a conversation and drafting now to like make sure that it's done properly in the way that you want it to be done. So a very common example would be like, oh, I want to name my parents as guardian, but like they're old. And what if I don't update my document and they're like 85? Like that's like by the time I die, that might be too old. So sort of just a discussion on, and this would be something an attorney, whether it be at Steward or wherever, would sort of like have to walk through all these various iterations with you, which can be painful to do. But like it's one of those things where you want to just make sure you're turning over every stone when it comes to these like big questions. So that's on Guardian. Sort of piggybacking back off of that is people want to know, like, okay, well, how are my children going to be provided for? Like, what if I want to name my sister as guardian, but like she's terrible with money? Like, how is that handled? So this might be a good time to sort of talk about an aspect of an estate plan, which is something called lifetime trusts, which can be established for children. It's very common for people of all wealth brackets to have all of their assets go to their children in what's called a lifetime trust. And what this means is that a trustee sort of manages the money, discretionarily distributes out money to your child or grandkids or whomever. And this is helpful because it allows for continued oversight. It helps with flexibility because today when you're creating this document, you don't know what your kid's going to be like in 20, 30 years. I know me and my siblings have really fluctuated in how good we would be with money over the course of time. It helps with divorce and creditor protection. So if your kid was going to get divorced, those assets wouldn't be accessible in the divorce proceeding, and sort of just those kinds of things. But then, with that, there come additional questions. Who should be the trustee? How does the child get, more control over those assets as they get older and hopefully more mature and able to sort of handle money? And so those are sort of the questions that you run into when you're talking about how these things work. And it kind of, you know, normally it's very normal for more questions to flow out as answers are given, which is great. Another one that comes up is, well, what if I'm alive, but like I'm in a coma or something happens to me? Like how does stuff get dealt with? So that's, to the extent you funded your revocable trust, the trustee would be able to do that, which at that point would most likely be a spouse or some other trusted individual. And then Meg had touched on two other documents, which would be the financial power of attorney. So this would allow somebody who is your agent to access your financial accounts if they needed to. So let's say, you had to pay rent and you couldn't do that, this person would be able to go into the bank and be like, I need this money, move this around. The other document is the healthcare proxy and living will, which this one is the toughest document for people to get through, it seems. But this sort of describes, well, it appoints somebody to make healthcare decisions for you, and then it describes how you would want decisions to be made. So, whether you want to be kept alive as long as possible or not, which is always like a tough conversation. But yeah, so these are sort of the questions. I know I went through a lot at you, so I'll pause there, but
No, I think that was super helpful and can definitely give people an idea of what they should be thinking about. Um, I guess before we wrap it up with kind of how working with Steward and Domain works together, I guess my last question, and then obviously we'll go do some Q&A too, is what are some of the most important reasons to have estate planning in place? I feel like we've talked about a lot, but if you could just summarize it, the two of you, into, maybe two or three things to leave people with, that would be awesome.
Yeah, I would say for families with minor children, it's naming those guardians, making sure that they are taken care of with the right people. Pets can be included in that as well. You can specify caregivers for pets, which is really important for a lot of folks. Preventing any family conflict. Not having a plan in place can cause a lot of family conflict. I have seen firsthand. So definitely put your wishes to paper and make sure it's legally binding. And then avoiding, we've talked about probate a lot, but like avoiding that probate process. I think a lot of people often think like, oh my gosh, a trust is so expensive. But when you compare it to the cost of probate, it is a fraction of the cost. So it's like, why not dedicate that amount that would be going to probate to people that you actually want it to go to versus the government? So and then I would just say like overall making things easier for your surviving loved ones, not having to let them guess what you would have wanted and what your wishes were. It's just you have everything specified. I've seen some very, very organized estate planning binders over the years, and the more organized you can get and give that to somebody while they're going through that grieving process is an amazing gift. It's like, let that be your last gift. Just be organized now and put up the work up front instead of letting them have to take months or years to figure this out on their own. So
Yeah, I think that's really important. And so, just to pivot a little bit, then to summarize, we're obviously very excited to partner with you and your firm for our comprehensive clients to have this benefit and make sure that clients really have that great concierge approach to having their estate planning done, and just everything that it includes. Could you share a little bit more about what that process does look like and what onboarding looks like to the Steward platform, and what our clients can expect from their estate plan with you guys?
yeah, well, the domain money family or group partner, I don't know. Partners have
Yeah.
been really wonderful to work with thus far, and you guys have been sending over like a warm intro to myself or our product specialist. And from there, we set up the clients with an onboarding call. So during that onboarding call, we'll get folks logged into their account. They'll answer a whole bunch of different questions. We do use some really great AI to gather that initial intake and answers to those questions. And then we use those answers to start drafting the documents behind the scenes. After that call, the clients will meet with an attorney, review anything that may be outstanding or needing some legal advice. The attorney can also make recommendations based on that initial intake that the client did. And after that call, we'll finish up the documents, send them over to the clients to review. If there's any questions or changes that need to happen, we can definitely answer those questions or make those changes. And then after that call or after documents have been approved, then we send out a notary to the client's home so that you can get your documents notarized and make them legally binding. And then if folks need property transferred into the trust as well, we do support transferring one deed. And we will guide through the trust funding process, which can seem very daunting, but I promise it's not as crazy as it sounds. So we help through that as well.
Okay, awesome. Well, with that, then I will open it up to the audience for any questions. So let's see if we get any other questions rolling in. Meg or Samantha, if you guys have anything else to add in the meantime while we let them roll in, feel free to chime in. One thing I'll add in, just one more note too, is that through your domain money plan, you have coaching sessions that you can use throughout the course of the year. Sometimes that's for year-end tax planning. Sometimes it's for portfolio rebalances. But another great way that we find our comprehensive clients using our coaching sessions is to actually help with the onboarding to Steward and to help kind of be a second set of ears or just another person there for you. So we're always happy to help and make sure that this process gets or is as seamless as possible for you. And so I have my first question rolling in. So let me grab that. So the question is that they were in and out of the webinar, so they may have missed this. But where is the fee structure and how many attorneys do you have on staff out of curiosity? And so I'll answer this from the domain money side. The cost of doing estate planning with Steward is included in the cost of your domain money membership, which is $7,800 for the full first year. And so that's how the fee is. It's part of your domain money financial plan. But then Megan, Samantha, if you guys want to touch a little bit more on the staff and where the attorneys are, that'd be great.
Yeah. All the attorneys that we work with are not employees of Steward. We do contract with them and have really good working relationship with them. They also go through a very extensive vetting process. We have about, I want to say like 5 core partners, and then we also have local counsel that will run through some things through as well. It's always changing. Like we'll add on new attorneys who are client facing or can provide local counsel as well. So that fluctuates, but you would be working with one attorney throughout the process. You're not working with many different attorneys. You're working with one attorney who can give you specific legal advice based on your situation. And then you're working with one concierge member as well who will be guiding you through the process.
And so this isn't specific to that, but I do just want to note it is so, as an attorney who has done this with various different types of clients, it is my favorite clients to work with are always the clients that I also work closely with, sort of like their investment team. And that's just because it makes things so much easier in terms of like knowing what people have, knowing what makes the most sense, moving assets into things. And it also is helpful for the client or the member because, I can bypass as an attorney, like asking questions to the client and can immediately just go over to the investment team, which is like very, very helpful. And it sort of just streamlines the process for everybody. So I just can't express enough how much I love when there's like a good communication with an investment team.
Absolutely. And I got another question here, and this is a domain money specific one for a client who has started or was about to start the process with wealth.com. And to give a little bit of a difference, as we've been talking about Steward is our partner for our comprehensive plans. So there is it's much more there's that concierge and the actual attorney support included, as well as just a deeper understanding of the entire estate planning needs for you and your family and helping you figure out exactly what documents you need, as well as that the notary that will come out to you. And so it's just a much more handheld process, if you will. For our lower tiers, we do offer access to wealth.com, and it's your CFP can still help you through that onboarding process as well, but it's not as in depth as the process with Steward, from like the hand holding from A to B with the notaries and all of that. So I'd be happy to chat with you offline a little bit more about the differences. If you are interested in working with Steward through Domain, then we can talk about the transition of membership or what that might look like. So I'd be happy to take this one offline, but that just gives you a little bit of color. We do have access to kind of some lighter estate planning resources under our other tiers if you're not in the comprehensive membership. And I've got another one rolling in here. What are some of the most common estate planning mistakes you see people make, and how do you help clients avoid them? There's something that you touched on, Samantha, earlier of like that your guardian doesn't have to be the same person as your trustee, which in my experience in financial planning, I feel like that's a really important one. Not necessarily that I've seen people make, but that comes up in conversation is there's often going to be different people that you want actually caring for your child day to day. And then there might be a separate person who would be the one managing the finances. So I would love if you could add a couple comments on that, or maybe pros and cons. I'm sure there's cons of it not being the same person as well. But if you have any other examples too, I would love for you to share.
So the pros are that for sure you feel comfortable naming somebody who can handle the financial stuff, and then you have the person who gives like the guardian stuff. And I know like most people aren't necessarily good at both. I guess I don't want to say most people, but many people aren't necessarily good at both. So it's nice to be able to sort of like bifurcate those duties. The cons are, you know, anticipating the needs of the child. There needs to be a good communication between the trustee and the guardian, because you know they need to be able to be providing for the child, and also the guardian, to make sure the guardian can provide well for the child. So I would say, like, if the person you want to name as guardian and the person you want to name as trustee hate each other, like that's probably not a good idea. But for the most part, people seem to like have sort of a circle of people, or at least a couple people that they feel comfortable in one or the other role. um, some other, I guess, like mistakes I've seen, like obviously, like not to belabor the point, but not having an estate plan in place would be the biggest mistake. Another one would be, not updating to reflect certain things. For example, like if you get divorced and remarried and you have a blended family, like your prior estate plan is not going to help you sort of in that dynamic if you wanted it to be a different plan, right? So like there are things that you have to do as like the person, as like the client. You have to reach out and be like, this is what's going on. I need to like have this changed. Um from an attorney side, I guess, like, you know, I can't speak to this from experience with working with the steward attorneys, but I would say like people not being able to sort of like anticipate the needs of the client and understand sort of what their overall goals are based on conversations. I think that's like where a lot of the benefit of having a lawyer comes in, is like they can make decisions for you because they know what decision you would want to make based on like all of these sort of conversations, and so it becomes a less of an overwhelming process.
Very helpful. Any other questions rolling in? I think we've answered everything in the queue so far. Actually, I just got one more rolling, but I am going to share my screen again for anyone who hasn't chatted with the Domain Money team yet. This QR code will take you to book that free strategy session I mentioned, where we can chat more about what your goals are and what you're looking for help with and what makes sense, and where we go from there. So free 30-minute strategy session with someone on my team, and we'll make sure that we answer all the questions you have. If there's something that you maybe don't want to ask on the call today, but want to talk one-on-one with somebody, then that would be a great place to go as well. Let's see, any other questions? Last call for questions. We've got about 5 minutes left. I'll leave it open for a second. But while we wait for that, Meg and Samantha, thank you so much for joining us today. Like, this is really valuable to give everyone a little bit more insight into the importance of estate planning and why it might be relevant to their situation. And like we said, we're all about keeping more money in our clients' pockets, as well as helping them live for or prepare not only themselves, but their families for a bright future. And I feel like estate planning just really ties in well with our philosophy here at Domain. So very excited for this partnership and to have you guys on board for our comprehensive clients now moving forward too.
Thanks for having us.
Yeah, it was a pleasure.
Okay, one more question just rolled in. Do you do LLCs, for example, to put a second home or rental property inside of a trust? That's a little bit, I think, of a loaded question. So I don't know, Samantha or Meg, which one of you wants to take that one?
We don't do LLCs here.
Okay.
Sam. Yeah, we don't do LLCs at Steward, so you would have to set that up beforehand. Um, but that is a good idea. Like we have seen LLCs transferred into trust, obviously. So and putting homes into an LLC. So yeah, we don't do LLCs here, unfortunately.
I mean, I guess yet or now, but I
Correct.
would
True.
say, hey, that's a good idea. Like, I always love being able to transfer an LLC interest as opposed to having to retitle a real estate asset. You know, you never know what's going to happen or where you want to move it to. But I mean, to answer your question specifically, currently, no, we do not.
Fair enough. All right. I think that's everything. And then if anyone does have any follow-up questions, you can always reach out to me directly, and I can make sure that I get you in touch with the right person. So again, I'm Adriana at Domain. Adriana.adams@domainmoney.com is the best way to get a hold of me. And you can also book a free strategy session here to meet with myself or someone on my team, and we'll take it from there.